So you have a new invention and you're thinking about filing a utility patent application in the US Patent Office. What are your chances of that patent being granted? Well, I'm going to talk about that on this video. And I have some ideas I want to share with you on how you can improve the likelihood that your patent will actually issue. Hi, my name is Carr Ferrell. I'm a Silicon Valley patent attorney. Welcome back to my channel. So what are the allowance rates for US patent applications in the Patent Office? Well, the answer to this question depends on who prepares your patent application and the technology area of your invention. Overall, the average allowance rate for US patent applications is somewhere between 65 and 75%. Jurastat reported numbers based on publicly available data in April 2023 and noted an allowance rate of 74%. Design patents were allowed at a rate of 86%. Now, although the allowance rate for patent applications prepared by licensed patent practitioners was very high, the numbers have been historically dismal for inventors who file and prosecute their own utility patent applications. In a 2012 study published by Kate Gowdery, she looked at 500 patent applications that were being prosecuted in the Patent Office. Half of those, 250 of those applications, were self-filed. They were pro se. The other half, 250, were prepared and filed by professionals. She reported in that study that of those 250 patent applications that were prepared and filed by individuals, some 76% of those patent applications ultimately became abandoned. This means that less than a quarter of those self-filed patent applications ever issued into granted patents. Looking at the other 250 patent applications in that study that were filed by professionals, the author noted that some 66% of those issued into granted patents. Now, where I believe it's completely possible for an individual inventor to prepare and file their own provisional patent application, I think preparing and filing your own utility application is a completely different project. Preparing and writing good patent applications is a skill that requires a long time to learn. This is not even a skill that's trained in law school, but rather one that's developed over several years of continual practice, often under the tutelage of an experienced mentor. Words used in patent applications often have very particular meanings, and it's important to get the descriptions right. These are legal documents, much like the documents that you might prepare in describing the property that you live on or a farm, the so-called metes and bounds of a real property description. Just as in buying and selling real estate and relying on a document that describes the property, in the same way, it's important that the patent application have professionally prepared descriptions. It might be true that with the help of the patent examiner, you may eventually be able to get the patent allowed. However, the value of the patent will likely be much less than if you actually had professional help in the preparation, filing, and prosecution of your application. There are lots of patent professionals to choose from. Every major city has patent attorneys that are standing by to help you. And it's very easy to find patent attorneys advertising on the internet. One bit of warning, however, and that is unless you already have a foreign filing license in place, be cautious about sending your patent application overseas to a patent attorney located in another country. Keep in mind that a foreign filing license is required in the US Patent Office before sending your patent application out of the country. Okay, we've seen that if you hire a patent professional to help you prepare your utility patent application, you'll have a much higher probability of getting allowance than you would if you were to try and prepare it yourself. The type of invention that you have also greatly affects your likelihood of allowance. Between the years 2017 and 2021, Jurastat reported that if you had an invention related to electrical components, semiconductors, or optical, your likelihood of allowance would be a whopping 86%. This is the highest allowance rate of all technical areas. And we also mentioned that design patents also enjoyed a high allowance rate. The most difficult areas to get allowance during the same time period were the biotechnology and life sciences areas. These included things like organic chemistry, immunology, and plant-related inventions. Business method patents have also had an historically low allowance rate. With that backdrop, what are some ways that we can improve our chances of getting our patent application allowed? Well, obviously the first way is to have your utility patent application prepared and filed by an experienced practitioner. You'll want to get someone with at least a few years of experience if your invention is important. If your patent attorney or patent agent is less experienced, you'll want to find someone that is working in a law firm and has supervision and mentorship. So you'll know that at least someone with experience is there and available to get help if the application gets into trouble, and hopefully the application preparation itself will be supervised. Writing good patent applications is a skill that takes a while to develop. Patent attorneys do not learn how to write great patent applications while they're in law school. Typically, this takes several years of practice and active mentorship by someone or with someone with much more experience. If you are working with a solo practitioner, I don't think it's at all rude to ask them, how many patent applications have you prepared and filed, and how many patents have you actually had issued? If the number is particularly low, you might ask the question, are you being supervised in your work? Is another attorney going to be looking over the patent application before it gets filed? Unfortunately, this isn't like getting your house painted, where you can tell if it's a good paint job or not. Most of us can't read a finished patent application draft and determine whether it's been well prepared or not. So for this reason, you'll want to make sure that your patent attorney really knows what he or she is doing. Okay, a second way to improve your chances of allowance is to consider performing a patent search. Now, you can perform this patent search yourself using Google or some other search engine or artificial intelligence platform. Or you can commission a professional patent searcher to perform the search for you. Although patent searches are not perfect, you can't expect a patent search to find every single piece of prior art that might be out there. They can be very useful in giving you some indication of how novel your invention really is. And a second benefit in getting a good patent search done is that it can help you in the preparation of your patent application. It can tell you what other inventors have been thinking about in this space, as well as perhaps providing some vocabulary that is commonly used in that particular area of the arts. A third way of improving your chances of getting your patent application allowed is to consider accelerating your application using the Patent Office Track 1 program. This Track 1 program allows you to pay an extra fee to the Patent Office and bring your patent application to the front of the line, and to receive early examination and probably some extra attention. The goal of the Patent Office is to complete the examination of Track 1 accelerated applications within 12 months. And this is shortened from the normal period of about 24 months, or perhaps even a little longer, for those applications, those inventions whose applications are not filed using the Track 1 program. Now, one of the benefits of accelerating your patent application is that Jurastat has found that accelerated patent applications have an allowance rate of 87% as opposed to 74% for those applications which were not accelerated. Now, there's a couple of reasons why I think this is so, but most importantly, the examiner picks up your patent application with an eye towards getting that application disposed of quickly. They're looking for reasons for allowance. And because the goal of everyone involved with this application is to get this application allowed and disposed of within the 12-month period, there's much greater collaboration, at least in my experience, between the examiner and the attorney. There's a negotiation process that typically takes place over the telephone, which greatly accelerates the movement of the patent application through the patent process. So in addition to getting the benefit of the acceleration of your patent application, objectively there's a higher allowance rate when your patent application follows the Track 1 program. A fourth way to improve your chances of getting your patent application allowed are to write more narrow, more focused claims. Be more realistic about the claim scope that you're really after and that you're willing to accept. Although it may feel good to file very broad claims in the patent office and see what the patent examiner will put up with, the reality is that very broad patent claims slow down the process. It's better, I believe, to file slightly more narrow claims. Ask for what you really want and what you really need with respect to your patent application. And once those claims are allowed, then you can file a continuation application and ask for more claim scope in a separate filing. Another way to greatly improve your chances of getting your patent application allowed is to get on the phone or have a video conference with your examiner regarding the prosecution of your case. If rejections come up or prior art is found, and you don't understand the rejection or you disagree with the rejection, getting an examiner on the phone, having an examiner interview is a great way not only to resolve the differences that you have with respect to the interpretation of the invention and the prior art, but also to build relationship and collaboration with the goal of getting this patent application in condition for allowance. And a final way to improve your chances of getting your patent application allowed is to take a look at other patents that have issued that are similar to yours. What kinds of rejections and objections were raised in the patent office with respect to their patents, and how can you address these preemptively? If you're dealing with a particularly difficult examiner, it may be helpful to take a look at some of the office actions that examiner has previously written in other patents and see what arguments were used to overcome those rejections. Patent examination is a public process with respect to issued patents, and so we're able to go back and look and see what paths others have successfully followed to get their patents issued. So as we've seen, the chances of getting an issued patent on your invention can actually be pretty high. It's not unusual for a skilled patent attorney to have an allowance rate in excess of 90%. Okay, that's really all I have to say today about improving the chances of getting your patent allowed. If you have any questions or other thoughts, maybe other ideas, put them in the comments section. We'd love to read about them. And if you need help with your company's patents or your company's patent portfolio or strategy, I'd love to talk to you. You can reach out to me at the email address below. In the meantime, I'll see you on the next video.